Record this matter before the court for the purpose of placing on the record a partial agreement between the parties. This hearing is being conducted via Zoom. Present is Attorney Ray Zagorski representing the plaintiff, father Matthew McCart. Mr. McCart is with Ms. Zagorski. In addition, Attorney Scott Longton is present representing defendant mother Anna Goins, and Ms. Goins is present. Good morning, Ms. Zagorski and Mr. Longton.
Good morning, Your Honor.
Good morning, Your Honor.
The court would note for the record this matter is scheduled for a full day evidentiary hearing on May 2nd, 2024. We have two very capable family law practitioners that have been working to try to facilitate an agreement between the parties, the parents of this 3-year-old child. They've worked through some issues. Is that correct? I wish to place that on the record, Ms. Zagorski.
Yes, Your Honor.
Check right here.
I couldn't hear you.
Did you not hear me?
There, that's better. I'm
Okay.
not sure. They're better. Okay, Mr. Zagorski, if you could please put the agreement on the record as you understand it.
Thank you, Your Honor. We have agreed that my client will exercise parenting time. Well, first of all, the parties will share joint legal custody. Physical custody will be with defendant mother. My client's parenting time will be every other weekend from Friday at 5 until Sunday at 5. And then on Wednesdays from 4 to 7. We would ask that my client's weekend start next weekend, Friday, May 3rd. We've agreed that child support will be $300 a month. We do need to meet with Ms. Patrick about the effective date. I think we have different ideas about when that should start. I believe this child is on public assistance, so I would say that $10 of that should be ordinary medical, because ordinary medical will be required. I think we've agreed that unless the parties agree otherwise, we'll use the front of the court holiday schedule, keep it simple. And that's what we've got so far. We do have some conversations to be had about exchanges and just general parenting time rules. And so if you're willing to accept our agreement so far, we would respectfully request the assistance of Ms. Patrick to work through some of those issues so that we can finalize this morning and vacate the hearing.
And that is all correct, Your Honor.
All right, thank you, Mr. Longton. Well, Mr. McCart and Ms. Goins, can you both please raise your right hand, Mr. Longton?
Thank
Right,
you.
Ms. Zagorski, if you can warn Mr. McCart regarding his understanding of this agreement.
Yes. Would you please state your name for the record, Matt?
Matt McCart.
And you heard the statements that I made to the judge about what we've agreed regarding custody and parenting time?
Yes.
You understand that this matter is scheduled for a hearing on May 2nd, and we could present our case to the judge and he could decide on a different schedule for you. Do you understand that?
Yes.
Similarly, he could conduct an evidentiary hearing regarding your income and Ms. Goins' income and reach a different conclusion about child support. You understand that?
Yes.
But you're agreeing to pay $300 a month?
Yes.
And do you believe that this parenting time is in River's best interests?
Yes.
And you understand if the court adopts this agreement, then this will be binding upon you until there's a change in circumstance.
Yes.
We can come back at some point in the future and argue that parenting time should be modified, but we would need a reason to do that. You understand that?
Yes.
And are you asking the court to adopt this agreement?
Yes.
Thank you. I have nothing further, Your Honor.
Thank you, Ms. Zagorski. Mr. Longton, do you have any questions for Mr. McCart?
No, I do not.
Questions for Ms. Goins, please.
Thank you, Your Honor. Ms. Goins, you've heard the settlement that was placed on the record, correct?
Yes.
You understand that by entering into this, you are waiving your right to trial.
Yes.
That had you gone to trial, Judge Braunlich could have ordered something similar or different, which could have been better or worse for you.
Yes.
And knowing that, you are asking the court to adopt this as your settlement agreement regarding custody, parenting time, and child support.
Yes.
You also understand that we've discussed custody, parenting time, and child support is always modifiable upon proper cause or change of circumstances.
Yes. Yes.
And that if something occurs that you believe is a change of circumstance or proper cause, you will discuss that with me and we will address it appropriately, correct?
Yes.
But at this time, you believe that this is in the best interest of your minor child, River, specifically at this time, correct?
Yes.
Okay. Do you have any questions for me or the court?
As far as what?
Just anything in general, with the exception of what we're going to go see Miss Patrick for here in just a few minutes.
No,
Okay.
not. I
Very
don't.
good. Nothing further, Your Honor.
Thank you, Mr. Longton. Ms. Gorski, do you have any questions for Ms. Goins?
No, thank you, Judge.
All right, so Mr. McCart, Ms. Goins, the court's of the opinion that any agreement reached by the parents is in the best interest of the minor child. The two of you know better what's best for River than anyone in this world. You don't want this court making these decisions. So I applaud you for reaching this agreement. And you're both represented by two very experienced, capable family law practitioners that have guided you. And they know that what's important is that the two of you, as parents, still be able to maintain a civil relationship. And I, in this court, and I was a practitioner, very often you have hearings, you start throwing stones at each other, then they're rocks, then you actually create more issues between the two as parents, which is not necessary. There's enough issues, enough challenges in this world, everyday life. Obviously, River will thrive if we're both on the same page. Yeah, obviously, you got a young child, but the two of you need to, now's the time. It's a good start, a good base to move forward, to work together on these issues. River needs an active dad and an active mom. So I applaud you for reaching this agreement. Far better off than this court, a stranger, making these decisions. Rest assured. So with that, I think Ms. Patrick is usually available at 9 o'clock. And she's present. So we're gonna have a talk with Ms. Patrick, our friend of the court, to see if she can assist you in working out any remaining small issues. If not, then if necessary, the court will address those this morning.
Very good. Thank you, Your Honor.
Thank you, Your Honor.
Welcome.
Thank you for accommodating us today.
I showed her pictures of Tyler. She goes, "Who's that?" I said, "That's your dad's dog." I was like, "She's a sweetheart." She's like, "Really?" I said, "Yeah, she likes to play too." She's like, "Awesome." She's
If that's okay
definitely
with
an
you, I
animal
may
lover.
bring it up for visitations. I may bring the dog with me if that's okay with you.
That's fine. She will have a blast, and there honestly that might break the ice a little bit too. And she does like animals. She's very much of an animal lover.
Oh yeah.
Very much.
Oh.
Yeah, she just
Okay,
had her
Albert.
cat, and her cat got outside, and we haven't been able to find him, so she's been pretty heartbroken over it.
Yeah, I don't have Squeaks anymore.
You don't have Squeakers? What happened to Squeakers?
He got old and passed away.
Oh, I'm sorry.
So he just one day just took off and never came back. Like, oh,
Well, his girlfriend passed away too, Jasmine.
oh yeah. I remember Jasmine.
We actually put her down last year.
Oh, did you?
Yeah. We're
I'm
kind of
surprised that
playing
cat-
onto it
I'm surprised that cat
because,
lived to be that long. That's crazy.
yeah,
Oh.
she lives pretty long.
How old was Jasmine?
Korns now session, Ashley Coops versus Scott Korns.
For the record, this matter is before the court. Subsequent to the parties have engaged in mediation with Mr. Walker from the front of the court. Hearing again is being conducted via Zoom. Present is Attorney Barry Savage representing the defendant Scott Korns. Mr. Korns appears to be present. Is Ashley Kuntz present on audio?
Yes.
Ms. Kuntz, can you hear the court?
Yes, I can.
Good morning.
Good morning.
So Mr. Savage, or Mr. Walker, who wants to place the agreement on the record?
Yes, I was not present during the mediation, but
Okay.
I've tried to make some notes here as to what an
Mr.
order.
Walker, you want Mr.
Yes.
Walker to state what he understands to be the agreement?
Pardon?
I can do
You want
that, Your
Mr.
Honor.
Walker?
Yeah.
Mr. Walker can state what he understands to be the agreement.
Yes, Your Honor, I can do that.
Okay, please, Mr. Walker.
The agreement is regarding parenting time, and father's parenting time will be as follows. It will be every other weekend at dates and times as the parties agree. It's going to occur in Temperance, Michigan. All parenting time will occur in Temperance, Michigan, and it will commence when father knows his work schedule. So the parties are going to communicate, and father will communicate that to mother what his work schedule is, and based off of that, they will determine when the weekends start for every other weekend. In the meantime, father is going to be able to video chat with the minor child also at times as the parties agree. And the parties have also agreed to come back to mediation on June 26th at 1:30 in the afternoon to look at possibly extending father's parenting time at that time. And that is, I believe, the extent of the agreement today, Your Honor.
Thank you. Can you repeat that date of continuing mediation, Mr. Walker? June
26th at 1:30 in the afternoon.
Right. Thank you, Mr. Walker. Mr. Savage, have you had an opportunity this morning to discuss with Mr. Korns this proposed resolution?
Yes, Mr. Korns has indicated to me he's satisfied with this resolution. Mr. Walker asked me to prepare an order and to have Ms. Coons sign the order. So I will prepare an order and basically, I guess it would be in the form of like a stipulation, an order, and have her sign it, and then we'll forward it to you for signature.
Thank you, Mr. Savage. Ms. Coons, did you hear the agreement placed on the record by Mr. Walker?
Yes, I did.
Is that a correct statement of your agreement?
Yes.
Wonderful. All right, Ms. Coons, Ms. Korns, can you both raise your right hand to be sworn, please?
182.
Do you both solemnly swear affirm, Ms. Coons, do you believe the agreement placed upon the record stated by Mr. Walker is in the best interest of your daughter, Isabella?
Yes.
Do you have any questions of Mr. Walker? Any questions of the court?
No, sir.
Okay. Mr. Savage, do you have any questions of Ms. Coons?
No, I have not. Other than I will submit the order to her directly, and she will sign it, get it back to me, I guess, and then I will forward it to you for filing.
Thank you. Thank you. If you can please wire Mr. Korns to confirm his agreement, likewise, that this agreement is in the best interest of the minor child, please.
I agree. Your Honor.
All right, Mr. Korns, do you agree this resolution is in the best interest of your daughter?
Yes.
All right. Do you have any questions?
Nope.
All right. The court would like to thank Mr. Walker for his assistance this morning. And Mr. Savage, that order should also reference the continued mediation date of June 26th at 1:30 with Mr. Walker. And that'll be a Zoom mediation. Do you have Mr. Walker's Zoom ID number to actually put in the order, Mr. Savage?
Yes, I have his number.
Okay. All right. The court finds the agreement reached by the parents to be in the best interest of the minor child. The court will accordingly adopt the agreement and will enter the order upon presentment. Thank you again, Mr. Walker. All right. That will conclude hearing. Everyone have a good rest of the day. Mr. Savage, Mr. Korns, Ms. Coons. This is Ashley Coons, President Audio.
Yes, I am, sir.
Right. Good afternoon, Ms. Coons. Mr. Walker, good afternoon.
Good afternoon, Your Honor.
What was the primary issue? Is it parenting time that was discussed in mediation?
Yes, Your Honor, as parenting time and child support.
Okay. Was there any agreement or resolution, or did parties need additional discovery?
There is an agreement, Your Honor, regarding child support and at least temporary agreement with parenting time with a continued mediation date.
Okay. Mr. Savage, do you want to put the agreement on the record, or do you want Mr. Walker to do so?
Mr. Walker graciously offered to undertake this task.
All right, Mr. Walker.
Yes, Your Honor. The parties have agreed that parenting time is going to be as follows. Defendant's parenting time will be every other weekend commencing July 6th of this year, 2024. It will be every other Saturday starting at 2 p.m. until 6 p.m. and every Sunday starting at 9 a.m. until 12:30 in the afternoon. Defendant Scott Korns has agreed that if he is unable to make his parenting time, he will notify Ashley on the Friday before his parenting time. He will also notify Ashley if he is going to be 15 minutes or more late to his parenting time. That is the extent of the parenting time agreement. Child support, we also discussed child support, and there's an agreement that Scott will pay, or defendant will pay to plaintiff, an amount of $496 per month for child support. That breaks down to $472 a month base support and $24 a month ordinary medical. That gives Scott a 75 average overnights per year. And any uninsured medical expenses would be paid 63%. Sure, that's right. 63% for defendant, 37% for plaintiff. We did not, however, Your Honor, I just thought of this, discuss an effective date for support. That is the one thing that I missed.
What was the last issue that was missed?
Yeah, the effective date of support.
Oh, effective. When was the motion filed for support? And the parties agree upon a commencement date, Mr. Savage? Ms.
The
Coons?
effective date
Yeah.
of this order will be March 1st. Correct, Mr. Walker?
Yes, Your Honor, actually, there is an order dated March 3rd that Your Honor signed. It says, child support shall be referred in front of the court with the effective date or start date of March 1st. So the
Okay,
order
very well.
already has an effective date of March 1st, 2024.
Very well. So, and of course, Mr. Savage, you'll prepare a uniform child support order with that child support amount as well as commencement date. Is that correct?
I didn't understand the court.
Mr. Savage, you'll prepare a uniform child support order reflecting that amount of child support as well as the commencement date?
Yes.
All right, Ms. Kuntz, did Mr. Walker accurately state your agreement regarding interim parenting time as well as child support?
Yes.
All right. And Mr. Savage, Mr. Walker accurately stated your client's agreement as well?
Yes.
Okay, do you wish to voir dire either party, Mr. Savage, regarding
No.
this agreement?
No, I do not. He's been very active in the discussion thus far.
Very well. Ms. Kuntz, do you have any questions for the court or any questions for Mr. Walker or any questions for Mr. Savage?
No, I do not, Your Honor.
Mr. Savage, you will prepare an order incorporating this agreement. Is there another mediation scheduled, Mr. Walker, or is that not necessary at this point?
Yes, Your Honor, there is a continued mediation scheduled for September 5th at 2:00 in the afternoon with myself.
At 2:00.
Yes.
And that would be regarding presumably parenting time primarily?
Yes, Your Honor.
And that's September 5th at 2:00?
Yes.
All right. So, Mr. Savage, you should probably indicate that in the record that the parties appear will mediate with Mr. Walker on September 5 at 2 p.m. via Zoom. And then they can subsequently appear before this court for review if necessary. Put it on the record. I'll make sure we're available, have the file up here. And if there's any issues the court needs to address, the court will be available to do so. So if you can put in the order that the parties meet with Mr. Walker September 5 at 2 p.m. via Zoom, and perhaps include the order Mr. Walker's Zoom ID number. Do you have that handy, Mr. Savage?
Your what?
Do you have Mr. Walker's Zoom number?
Yeah, yes, I have the Zoom number.
Okay. Perhaps we can put that in the order. Then the parties can subsequently appear before the court for review after they conclude with Mr. Walker on that date.
You want the Zoom numbers in that order?
All right. Ms. Kuntz, do you have is there any other concerns, questions on your part?
No, there's not, Your Honor.
All right. The court will adopt the agreement of the parties relative to child support and parenting time, and we'll see everyone back on September 5 after your 2 p.m. mediation with Mr. Walker. And Mr. Korns, obviously communication with Ms. Kuntz is the key. So please be considerate. I know it's a long distance, so if in fact there's a delay or you're unavailable, please notify her as soon as possible. All right, if there's nothing further, Mr. Savage, I will conclude this matter. Thank you, Mr. Walker, for your assistance. Thank you, Mr. Savage. Everyone can zoom out. Have a good rest of the afternoon.
Thank you, Your Honor.
Thank you.
You're welcome.
Court is recalling Braunlich McCart versus Goins.
For the record, this matter is back before the court for a Zoom review, subsequent to parties having conferred with Ms. Patrick from the front of the court this morning for perhaps the last hour. The court appreciates everyone's continued discussion about these issues. Ms. Patrick has made the following recommendation to address some outstanding remaining issues that with respect to parenting time exchanges, that parents and or the grandparents are permitted to do the parenting time exchanges. And during their respective parenting times, mom and dad should be substantially present for their parenting time. With respect to child support should be about $150 per month from June 1st, 2023 to April 30th, 2024. The arrears will be paid at the rate of $50 per month. And of course, the new amount of $300 that the price agreed upon, that will commence on presumably May 1st. of 2024. Finally, with respect to claiming the minor child as a dependent for tax purposes, it's recommended that the parties shall alternate. Plaintiff filer shall take the minor child as a tax exemption on even years and mother on odd years. I believe that appears to address the remaining outstanding issues. Ms. Gorski, your client's position on this recommendation?
Judge, we agree with everything that's been recommended. I would clarify that my client will take even numbered tax years. So he'll take 2024. Ms. Goins has had the exemption for the last 4 years. The only thing that we would ask is that his partner of 2 years, the woman with whom he resides, who also has a 4-year-old child herself, be permitted to do the exchanges if his parents or he were unavailable. His parents are in their 80s, and he's just concerned that there could be an instance, it's, it would be very unexpected. It's not something he would do regularly, but that she could be a backup in the event that his parents were unavailable because of their ages. That's the only thing.
And that was discussed at length with Ms. Patrick this morning. Is that correct?
It was, and I do not believe Ms. Goins agrees with her being permitted to do so. And the other thing I think is we're agreeing that the parties can text each other. My clients had a lot of trouble with app close. Ms. Patrick didn't say anything about this, but I think we're moving away from app close into text because he tries to send messages and they aren't going through the app. So Ms. Goins sent him a text today, he got it, and that appears to be more successful for them to communicate.
So, Your Honor, on the easiest first texting, yes, my client is agreeable to texting. I would recommend that they still keep app closed for the purposes of calendaring. We did have this issue before. Me and Ms. Zagorski did figure out what was going on with app close the last time. So I think we should coordinate that for the purposes of calendaring. If that's agreeable.
It's not working for my client, Scott.
Okay.
The soccer schedule by text or by app close?
I did get it.
In app close?
Yeah, but it's not, I just looked, it's not.
The
I
schedule.
do remember saying it. She did send it.
Yeah, it's not working on its phone.
So, Your Honor, me and Ms. Zagorski, we work very well together. We will figure out some type of calendaring of some sort for these parties so that, we'll figure out a different calendaring system somehow.
Yes, agreed.
Let me just text it.
Perhaps it's easiest if Mr. McCart gets a different phone, a different operating system. Maybe that could be the issue. Obviously, app close is certainly preferred by this court so that things are reduced to writing. We're not coming back on show causes every other month. So the court suggests Mr. McCart get a different phone. I mean,
Well,
this is
he's
important.
got an iPhone. I don't.
I've tried sending 3 messages and it just says.
Okay. The court was not aware parties had problem with the app close. I'm not sure why Mr. McCart's having problems. Maybe he needs to have a tech person look at his phone. But certainly the app close is preferred. So that will continue unless the parties can agree otherwise. And maybe the app close communication, then a text message, maybe both. So anyway.
Very good, Your Honor.
Mr. Longton.
Your Honor, as far as the exchange issues go, using the girlfriend Hadley, I think that would be completely inappropriate. I think Your Honor would agree. Miss Hadley has attempted to obtain multiple PPOs against Miss Goins, which have been denied, I believe, either by Your Honor or by one of the other judges in the court there. Miss Hadley has made numerous police reports regarding threats and harassment by my client. To put my client and Miss Hadley together, given the allegations by Hadley, could end in significant legal issues for one or both of them.
Where do the parties meet for exchanges right now? Is it curbside drop
No,
off? We've got 3 or 4 year old. It's still pretty young.
no,
Yeah.
they're at the sheriff's department because of the allegations made between the parties. Ms. Goins has alleged that my client is violent and abusive, but she sends her mom anyway. She doesn't ever come to the exchanges. So it's always at the sheriff's department.
All right, so that would continue. Obviously, Miss Hadley is under this recommendation would be permitted to supervise the child for a short period of time if Mr. McCart was held up at work or something. Is that correct? We just don't want her to have contact with Ms. Goins. Is that what the concern is?
There's,
Yeah, my client resides with Hadley Barron and her 4-year-old son. And River, the child in this case, knows her and likes her child. It's not anticipated that my client would have to use her. I just don't want him to face a show cause if he had to send her because his parents were unavailable. Like I said, they're in their 80s. I mean, he intends to go to the exchanges himself or send his mom usually.
Your Honor, I guess, Mr. McCart is always local for his parenting time. We've said multiple times, literally these parties live less than a mile away from each other. Mr. McCart's his business is within blocks of everything. So absent some type of extenuating circumstances, there's no reason Mr. McCart or his parents could not come and get the child. I just, erring on the side of caution, I would be extremely hesitant to have Miss Hadley, what's her last name? Barron.
Barron, B-A-R, Gwen.
So to have Miss Barron present for these exchanges.
All right. With respect to, we don't need, this minor child does not need turmoil between two adults. So to avoid that, the court will follow Mrs. Patrick's recommendation in that regard, that only the parents and grandparents will do the parenting time exchanges. Now, Ms. Sikorsky, if things change, if obviously the grandparents are in their 80s, they're presumably retired and normally available. So they, in the event Mr. McCart could not pick up or drop off, then the grandparents would do that. And if in fact he loses his parents and the parents are no longer available, then you petition the court, and hopefully maybe over time the things can simmer down between Ms. Barron and Ms. Goins. But at this point in time, the court will limit parenting time exchanges just to the parents and grandparents.
Okay, thank you.
The other issues, Mr. Longton.
Your Honor, the other issue the only issue that we had with the recommendation was the tax exemption. And the reason we have that is because the agreed upon child support amount with calculations was based upon mother having the tax exemption every year. The child tax exemption was never an issue brought up, even when we did the settlement or as part of the negotiations. It was not an issue brought up until we were already with Ms. Patrick. I believe it would be inappropriate to award Mr. McCart the tax exemption absent a finding of some type of basis to deviate from the formula, because the $300 per month is based upon my client having the child every year. Now, if we're going to deviate from the formula or grant Mr. McCart the tax exemption, then child support would actually go up on the years that he is claiming the child, because that would give him additional income. Child support would go up to approximately $427 per month. So, for argument's sake, we've already put a settlement on the record regarding the issue of child support going forward. I think it would be inappropriate to modify that agreement that's already been reached with the calculation of mother having that child tax exemption.
Okay, well, Mr. McCart can't have it both ways, Ms. Sikorsky. So either we, if the court's inclined to follow the recommendation and let the parties alternate claim the child's independent for tax purposes. But if so, we need to perhaps recalculate child support, or at least have it recalculated every even-numbered year.
Well, and Ms. Goins is welcome to file a motion after this tax year when he actually gets the benefit of claiming the minor child. She has had the benefit of claiming the minor child for the last 4 years. He hasn't claimed the child yet, so he hasn't had that benefit. And as you know, it amounts to $2,000 under the formula. I don't understand Mr. Longton's math. It's going to be a negligible amount because it is $2,000. The $300 that we agreed to today was a mediated amount. These are the business documents that I have provided to Mr. Longton during the course of discovery in this case. And we've imputed income to my client because his records show that he actually makes less. In the meantime, Ms. Goins, we put in at 40,000 when I think through tips and other income, she actually earns much more. She would tell you that her tax returns show 35,000. She has a good accountant. Regardless, we reached an amicable resolution and my client has never claimed this child. So after tax year 2024, when he files his taxes and he claims this child, if Ms. Goins wants to revisit the issue because going forward, the child support should be different, she has every right to do that. You know that it's routine. My client is going to, well, first of all, has voluntarily paid support in the past and is going to be paying support in the future. And so he should have the benefit of the exemption of every other year. It's common practice.
When the parties, when council can reach agreement about $300 a month, was there a discussion about Mr. McCart claiming the child as a dependent for tax purposes in alternate years?
No, Your Honor.
It was
So
assumed.
the court does not believe it's best interest of the child for each party to come back every year to recalculate support.
I agree.
So Mr. McCart can have it both ways, Mrs. Question. We're either going to recalculate support today, or I'm trying to minimize these parties having to come back at each other every year to recalculate support. So if the court's going to grant the alternate exemptions, what the court's going to do, then let's recalculate support this morning. Mr. Patrick,
Okay.
you can confer with the parties if we need to modify the amount of support. And if I'm open to any suggestions, Mr. Patrick, but I'm reluctant to see these parties have to come back every year to recalculate child support. I suppose we could do that. And but again, if in fact,
Your Honor,
things will change between now and then.
Your Honor, the average between the 427 when Mr. McCart would claim the two children, I'm sorry, the one child, which also includes his two children taken into consideration, versus the $300 when my client would claim the child every year, the average is $363.50 average between the 2 years.
How did giving him an additional $2,000 with that exemption result in a $137 swing? What incomes are you using? To get to $300, we used 40 for her and 30 for him.
And I am using the amount that was discussed with Ms. Patrick, actually increasing my client's income to the 40,000 above the 35,000, and using the $40,000 for Mr. McCart based upon his taxes.
That's not how we got to $300. You can't change their incomes when you change the exemption. We got to $300 with him at 30 and her at 40. It came to $298. So if you're going to include the exemption, you have to do it based on the original numbers.
But we also got to $300 based upon her claiming the child every year. So we can't have it both ways.
No, I'm saying put in him at 30 and her at 40 and give him the exemption with his two other kids and tell me what that number is.
And that's what I'm saying. The agreed upon, like I said, we should not even be discussing the tax exemptions because the agreed upon amount was an agreed upon amount with her claiming the child every year. What he's trying to do is circumvent and have buyer's remorse and now pull basically the wool over the eyes of the court and try to now claim the child as an exemption on opposite years, which should not even be occurring. So yes, I agree. The amount is an agreed upon amount, but then to come back and try to argue that he should now get the child as a tax exemption is inappropriate.
I agree, Mr. McCart can have it both ways. Ms. Patrick, can you give parties a few more minutes this morning to talk to them about this issue? We've got so far. The courts, I hate to see everything fall apart.
Yes, Your Honor.
Thank you, Your Honor.
McCart versus Goins.
Parties are back before this court currently via Zoom, subsequent to another discussion with Ms. Patrick regarding the issue of tax exemptions and child support. The court recognizes that the parties in council had spent considerable time with discovery, determining incomes of the respective parties, agreeing upon a child support amount of $300 commencing May 1st of 2024. However, it was suggested that the issue of tax exemptions was not specifically discussed as part of that agreement. And Ms. Patrick has suggested and is a revised recommendation that future reviews of child support will include consideration of the tax exemption. In other words, the mother will continue to claim the minor child as a tax purposes until further order of the court, but any future reviews of child support will require that the referee include consideration of that tax exemption. That's revised recommendation. The other recommendations, the court previously noted that parties should be substantially present during their parenting time. Parents and only parents and grandparents should do the parenting time exchanges. Ms. Corsi, is that revised recommendation acceptable to your client?
Fine, Your Honor.
I'm sorry, you're muted.
I said it's fine. Thank you.
Thank you. Mr. Longton.
Yes, it is agreeable, and I believe that that would be in accordance with the statute, Your Honor.
Wonderful. I thank the court. Thanks, Ms. Patrick, for her assistance. Obviously, Mr. Longton, Ms. Zagorski, there are creative ways for the parents to handle this. For example, they could each meet with the same tax preparer if possible in any given year and see who would get the better bang for the buck. And if someone gets a better refund, that person would claim the benefit for tax purposes. They can agree between themselves and put that money into an account for River for future educational expenses. So there are, if they can work together, and the court hopes they can with this agreement and move forward and in future years determine who would benefit most in terms of getting the larger refund by claiming the child, and to the extent that that refund can be placed in an account for the benefit of the minor child. Just a suggestion. All right, so Mr. McCart, I think they were both sworn. Is that correct?
Yes, Your Honor, you did swear them in earlier.
Any further voir dire, Ms. Zagorski, of your client?
No, thank you.
Mr. Longton?
No, Your Honor, satisfied.
All right. Again, the court would like to thank and acknowledge Ms. Patrick, as well as, of course, Mr. Zagorski and Mr. Longton for their efforts to facilitate this resolution. Mr. McCart, Ms. Goins, have been well served by your attorneys facilitating this resolution. Hopefully, this will give you a base to work together for your son. The court would hope that be the case. Little things are important. I've said this before. Mr. McCart, always make sure that River has a Mother's Day card for mom. Those little things mean a lot to a child. Same with Miss Goins. When Father's Day comes up, make sure River has a Father's Day card for his dad. Those things mean a lot to children. So with this agreement, the court will adopt the revised agreement. Copy mailed out to counsel, and the court will vacate the one-day evidentiary hearing set for May 2nd at 8:30.
Thank you, Your Honor.
Thank you all. You can
Have
zoom
a good
out.
day.
Thank you. Ms. Patrick.
You're welcome, Your Honor.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Eric Chappell, representing the plaintiff Angela Jones. Ms. Jones appears to be present. In addition, Attorney John DQ is present, representing the defendant Greg Peppel, and Mr. Peppel is also present. Mediation was previously scheduled for today's date. Mr. Walker, the parties informed the court that the mediation was being adjourned. Apparently, discovery has not been completed. It was anticipated it would be, but it's not. So the parties have agreed to mediate with Mr. Walker on June 6th at 8:30. Is that the correct date and time?
Yes, Your Honor.
Right, and since and we have time performance guidelines in Michigan, the court would like to entertain the proofs as well as any other outstanding issues so that we can move forward with the mediation in a meaningful fashion on June 6th. The court, Ms. Jones and Mr. Peppel, will simply take some jurisdiction, take brief testimony that the court has jurisdiction, that there's been a breakdown of the marriage, and that there are no minor children, and that Ms. Jones is not now pregnant. The court will reserve all outstanding issues. I'm simply going to stop the clock. So Ms. Jones and Mr.
Did you
Peppel,
reside in that address at least 180 days prior to the filing of your complaint for divorce in this case,
Yes,
including the immediate 10 days prior to the filing of the
Yes.
complaint? In fact, you resided in that residence for how long?
almost about 2.5 years.
Okay, and that's located in Monroe County, correct?
Correct.
Okay, is it true that you were married to Mr. Peppel on July 23, 2021 in White House, Ohio?
Correct.
No children were born during the marriage. Is that also accurate?
Correct.
Okay, and can you confirm for me that you are not now pregnant?
I am not pregnant.
Okay, you've alleged in your complaint that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and that there's no reasonable likelihood that the marriage can be preserved. Was that a true
That's-
statement at the time you filed the complaint for divorce?
That's true.
Okay, and is it still a true statement today?
It is.
Okay, and have you and Mr. Peppel, in fact, separated at this point, meaning you're not living together under one roof?
Yes, we have.
Okay, so it's your request that based upon that allegation that the court ultimately grant you a judgment of divorce based upon incompatibility?
Yes, please.
Okay, all right. Thank you. No further questions, Your Honor.
Thank you, Mr. Chappell. Mr. DQ, do you have any questions for Ms. Jones?
I do not, sir.
Any questions for Mr. Peppel?
Mr. Peppel, did you hear everything that Angela stated?
Yes,
Anything that was incorrect?
I did not hear anything incorrect.
No further questions, Your Honor.
Thank you, Mr. DQ. Mr. Chappell, you don't have any questions for Mr. Peppel, do you?
I do not.
Very well. Based on the testimony that's been presented this afternoon, as well as complaint files, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There appears to be no reasonable likelihood that the marriage can be preserved. At this point in time, the court will simply reserve all outstanding issues, or that the parties appear with Mr. Walker to mediate on June 6, 2024 at 8:30 a.m. and subsequently appear before this court for a continued pretrial conference. With that, the court was informed this afternoon that Mr. Chappell has filed a motion to compel. Got a tentative hearing date of May 8th at 2:15, and the court was hoping we could address that today.
Your Honor, I haven't received that. Didn't get any communication from Mr. Chappell that he was going to file that, and I am not available on May 8th. I'll suggest this. Mr. Peppel, can we have those answers within 14 days?
Absolutely.
That's my suggestion, Your Honor, is that we'll have those to Mr. Chappell in 14 days.
And do those interrogatories address your inquiries about this alleged personal injury settlement, Mr. Chappell?
They do, Your Honor. They consist of what looks like a very general set of discovery, because I've not received a copy of Mr. Peppel's DRVF. So I've got general inquiries regarding assets and things such as that. And then I do ask for information regarding his settlements, payment through his firm, items such as that.
It appears to Mr. DQ that those issues are relevant in terms of assets. If Mr. Peppel received a significant personal injury settlement this year, that's in an IOLTA account, perhaps maybe not to release the IOLTA account, but certainly information under oath in terms of the fee that he received or this holding and where it's at. It's all relevant. So I would hope that there'd be compliance with those interrogatories, short of making a complete copy of the IOLTA account.
The only reason I ask for that, Your Honor, is that as the settlement funds come in, if they come in on one check, obviously they're probably deposited, first into IOLTA. It's very feasible that a lawyer could keep his money in an IOLTA account. And, because, they don't want to declare income within any particular time period. And that was the reason I asked for it, was to see if there's any funds that are being retained in the IOLTA to prevent the declaration of income.
Your Honor, may I address the court?
You want to talk to Mr. DQ first?
Well, Mr. Peppel, okay, Greg, hold on. Your Honor, I got a problem with addressing this issue when I don't even have the motion in front of me and I haven't gone through the objections yet. So,
everyone knows what Mr. Chappell's looking for. I'm just trying to avoid having him come back in a couple weeks.
Well, I've suggested we'll have those answers in 14 days. I don't understand why that's a problem.
I thought perhaps you would say, it's not relevant. I'm not going to respond. It's not relevant. I'm just trying to get through that issue, Mr. DQ. But if in fact you're suggesting that, yes, that information will be provided, then it should not be an issue. Mr. Chappell, I don't know what are you going to do with this May date if Mr. DQ is not available? Are you available?
Yeah, and just to be clear, we had just got a date from the court. I have not signed the motion yet, but we got the date, so it's part of the process. So it's not like, it's not like I haven't sent any, I don't have anything that I'm sending to Mr. DQ yet. All we did was.
Understand.
Yep.
Understand. I'm trying to be efficient since we got all the parties here. If in fact May 8th and Mr. DQ is not available, are you available earlier than May 8th to Mr. DQ? At least we can all agree upon a date you're going to address this if necessary. Hopefully, Mr. Chappell can vacate that hearing date.
Yep, I will, Your Honor.
Just trying to be efficient.
I understand.
Your Honor, may I address the court?
It's up to you, Mr. Peppel.
Just for the record, in case the court has not recognized, I am a licensed attorney in both Ohio and Michigan. I just want to, I guess, ask one inquiry since we're all here for the purposes of efficiency. I have been asked to provide IOLTA account information from my firm. I don't have a problem specifically producing the information on the IOLTA account. I do have a concern disclosing the identity of clients as it relates to their funds. Those names are clearly protected by attorney-client privilege, and the fact that they would have funds in our account, I don't think is anything that I could disclose, although I can certainly disclose amounts and any amounts that would be mine in an IOLTA account.
The court understands that. I think what's more relevant is the amounts that are due to you, and the dates that they were realized. I don't know if we need the name of the plaintiff.
Happy to start with that, Your Honor.
And that's
Your Honor, you should also know that he is not a sole proprietor. There are partners involved in this. And we also, there has been informal inquiry as to getting information about Ms. Jones's trust account, income, et cetera, over the time period of the marriage as well. And we're going to have to get that apparently going to have to do that through a formal process as well.
Ms. Jones is an attorney as well?
No.
Oh.
She's a nurse, Your Honor.
Reference to a trust account.
Your Honor, she has a, and I believe it's clearly separate. She has a sum of money that was received. She's a widower, was a widower before she met Mr. Peppel. There was a sum of money that was received from her now dead husband, his estate. And it was something realized way before the marriage, and it's been maintained in a separate account ever since.
If it's not been commingled, it'd be this court's opinion. It's not a marital asset. This is a short-term marriage. And hopefully the parties can come to their own settlement with such a short-term marriage.
Yep.
So I would think, Your Honor, we suggest it has been commingled, so it's relevant.
Okay. All right, so how about May 7th at 2:30, Mr. Chappell, for your motion hearing?
I can't do any date that week, Your Honor. I'm involved in a arbitration in Detroit.
How about May 21st?
I could do that.
I can do the morning, Your Honor.
9 a.m.?
Yep.
All right, so Mr. Chaplain, Mr. DQ, likewise, if you want to follow a motion, perhaps you can notice up to the same date and time, May 21st, 9 a.m. And the court would agree if Mr. Chaplain, if in fact it's a office IOLTA account, I'm not, the court's not convinced that that entire IOLTA account should be disclosed, perhaps just simply specific pointed interrogatories. Hopefully you can get that information under oath from Mr. Peppel that you're seeking without having to release an office IOLTA account or disclosing names of the clients.
Yep.
So let's address all these matters on May 21st at 9 a.m. if the parties have not resolved them prior thereto. And notice that up, Mr. Chappell, and court will mail out notice of a continued pretrial after the June 6th mediation with Mr. Walker at 8:30.
Thank you, Your Honor.
Anything further?
No, sir.
Thank you.
Okay. All right. Thank you, Mr. Peppel, for appearing. Ms. Jones, that will conclude this matter. Everyone can zoom out. Have a good rest of the day.
Good afternoon.
It's just a little bit echoey.
Thanks, Judge.
Okay.
Welcome.
Yeah, it's not
Some
bad.
Some people have complained they can't hear me call the case, so I was just wondering how everybody.
No, I can hear you fine. It's how it usually sounds.
Good, thank you.
You're welcome.
Now session, Amanda Beaudoin versus Curtis Beaudoin.
Good afternoon, Ms. Spencer.
Good afternoon, Your Honor.
The party's name, is it pronounced Beaudoin?
Correct.
Okay, Beaudoin. The French name?
Correct.
You've got this matter is before the court this afternoon for entry of a proposed judgment of divorce. Court file contains a judgment which appears approved by both parties. Ms. Spencer, how long have the parties been separated? Approximately?
I believe they are still living together at this time, but they have been contemplating divorce for quite some time, to my knowledge.
The reason the court's making an inquiry, Mrs. Beaudoin, is there's a statutory 6-month waiting period in the state of Michigan in which in any divorce case in which there's a minor child, just to make sure with no chance of reconciliation. And of course, the 6 months begins to run on the date the divorce complaint was filed. Divorce complaint was filed just February 14th, which the 6 months will be August 14th. But this court does have the authority, and I'm willing to waive that, the balance of waiting period, provided you both agree and you believe it's being best interest for your children to waive that waiting period so you can move forward in life. So we can address that during your testimony this afternoon. Ms. Beaudoin, can you both please raise your right hand? There you go. Thank you. All right, Ms. Spencer, you can begin with Ms. Beaudoin, please.
Thank you. Can you please state your full name?
Amanda Nicole Beaudoin.
Thank you. Is it true that you are the plaintiff in this matter and filed the complaint for divorce?
Yes.
Okay. And at the time that you filed this complaint for divorce, did you continuously live in Michigan for at least 180 days prior to?
Yes.
And were you a resident of Monroe County for at least 10 days prior to the filing?
Yes.
And is it true that you and the defendant were married in Gibraltar, Michigan on October 10th of 2009?
Yes.
And is it true that there are 2 minor children born during the marriage?
Yes.
Okay. And are you pregnant at this time?
No.
Okay. And is it true that you both have property and debts to be divided?
Yes.
Okay. And do you believe that there is any chance of reconciliation?
No.
Okay. And so then is it true that there's been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Okay. And have you had a chance to review the judgment of divorce?
Yes.
Okay. And is it true that you have already signed that?
Yes.
Okay. And is it true then that you are asking the court to waive the 60-day statutory, or I'm sorry, the 6-month statutory waiting period, and enter a divorce prior to that waiting period?
Yes.
Okay. And do you believe that it's in the best interest of the minor children for the divorce to be entered prior to that 6-month statutory waiting period?
Yes.
Okay. And then regarding the judgment, is it true that you and the defendant are asking that you both be granted joint legal custody and joint physical custody?
Yes.
Okay. And then for parenting time, is it true that you are requesting that you guys just, exercise reasonable and liberal parenting time as you guys mutually agree upon?
Yes.
Okay. And you believe that that is in the best interest of the minor child to exercise parenting time in that way?
Yes.
Okay. And then regarding holiday parenting time or days of special meaning, is it true that you guys are planning on mutually agreeing upon parenting time for those days? And then if you can't agree, then you would use the friend of the court schedule?
Yes.
Okay. And regarding child support, is it your understanding that the defendant is going to be paying child support consistent with the Uniform Child Support Order, and that would be in the amount for both children of $307 per month?
Yes.
Okay. And then is it true that you are requesting that the court not order any spousal support for either party?
Yes.
And do you understand that once the judgment is entered saying that there is no spousal support, you can never come back and ask the court to change that?
Right. Yes.
Okay. And then for health insurance for the minor children, is it true that the defendant plans to cover the minor children on his health insurance?
Yes.
Okay. And then for claiming the children on taxes, is it your understanding that you would be claiming the minor child Allison each year, and then the defendant would be claiming Tyler each year, and when only one child remains, you guys would go back and forth in claiming that one child?
Correct. Yes.
Okay. And regarding the real property, is it your understanding that the defendant is to be awarded the marital home?
Yes.
Okay. And then regarding the camping ground property, is it true that you are requesting that you be awarded that?
Yes.
Okay. And regarding vehicles, is it true that you're each asking to keep your own vehicle?
Yes.
Okay. And regarding personal property, is it true that you guys are going to divide that property as mutually agreed upon, or you may have already done it at this rate, but does that sound accurate?
Yes.
Okay. Regarding retirement accounts, is it your understanding that you were awarded 1/2 of the defendant's auto warehousing company 401k profit sharing plan?
Yes.
Okay. And is it your understanding that Ann Pastrana is going to be hired to prepare the necessary QDRO for that division?
Yes.
Okay. And then you are asking to be awarded your retirement accounts free and clear, correct?
Yes.
Regarding life insurance, you guys are each just going to be awarded each of your own life insurance. It's already in your name, correct?
Right.
Okay. And then for bank accounts, you're each going to be awarded your bank accounts in your own individual names, correct?
Yes.
Okay. And then for debts, is it true that you are asking that you each retain whatever debts are in your own personal names?
Yes.
Okay. And is it true that you're also requesting that you be allowed at any point after the judgment to restore your name back to Amanda Nicole Szronka if you wish to do so?
Yes.
Okay. And have you disclosed all of the property in the judgment?
Yes.
Okay, so there's no property that you haven't disclosed that would need to be disclosed at this time, correct?
Correct.
Okay. And again, you think everything that has been stated today and that you're asking the court to order is in the children's best interest, correct?
Yes. Yes.
And were you satisfied with my office's representation of you in this matter?
Yes.
Okay. Thank you. Nothing further.
Thank you, Ms. Spencer. Sir, can you please state your name and current mailing address for the record?
Yes. Curtis Daniel Beaudoin.
Thank you. Mr. Beaudoin, is it true that you signed your name to this proposed judgment approving the terms and conditions contained therein?
Yes, Your Honor.
Did you do so freely and voluntarily?
Yes, Your Honor.
You understand that even though Ms. Spencer prepared this document, which assists both of you, she represents your wife, Amanda, and her loyalties lie with Amanda. Do you understand that, sir?
Yes, Your Honor.
Do you likewise believe it's in the best interest of your children that the court enter this judgment sooner than later and waive that statutory 6-month waiting period?
I do, Your Honor.
Do you have any questions for the court?
I do not.
Do you have any questions for Ms. Spencer?
I do not.
Thank you. Ms. Spencer, do you have any questions, Mr. Beaudoin?
I do not. Thank you.
Right, Ms. Spencer, the original judgment is actually in the file attached to your motion, so you'll need to submit a copy of that, another copy of that for the court to sign, because I can't take this out of the file once it's been calendared in the court file.
Okay, I can do that.
Very well, the court would like to thank Ms. Spencer for assistance in helping me facilitate the resolution of this matter. The court would applaud the two of you for reaching your own agreement, especially in co-parent your children. That's wonderful. Your children will thrive if you're on the same page. And there will be challenges in the future, but they can all be addressed through effective communication. So please keep that in mind. Based upon the testimony that's been presented this afternoon, as well as plain file in this matter, the court finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that the opposite matrimony has been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. According upon the receipt of the proposed judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter, granting a divorce and bonds of matrimony. Good luck to both of you. That will conclude this hearing. You can all zoom out. Have the rest of the day. Thank you, Ms. Spencer.
Thank you, Ron.
Thank you, Your Honor.
Thank you.